For the most part, no, I'm afraid not. In Queensland, if you're prosecuted before a judge or jury in the district or Supreme Court on an indictable offence, even if you're found to be totally innocent and you've spent a truckload of money defending yourself, you won't recover any of the costs you've spent in the process. Obviously, many would argue that's pretty unjust, but I'm afraid it's just the way it is. Of course, the converse applies. If you're convicted, the Crown can't make you pay its costs, but that's not much of a consolation for an innocent defendant who's been put through the ringer and has perhaps gone deeply into debt to clear their name, and then they find that having been totally vindicated, they're left to pick up the tab. Unfortunately, as I said, that's just the way it is. Curiously, if the prosecution is brought in the Magistrates' Court and the defendant is acquitted of the charge, then costs can be sought in the Magistrates' Court and recovered from the police. Of course, there are strict limitations that apply to that also. For starters, the amount you can recover is limited to a figure set out in the regulations to the Justices Act, and perhaps not surprisingly, the costs allowed by the regulations are significantly less than what you're likely to be charged by your lawyers. A court can award you a higher amount, but only if you're able to demonstrate that the matter was especially difficult, complex, or important. There are also some other criteria that affect whether you'll be awarded costs or not, including questions such as whether the prosecution was brought in good faith, whether was it conducted in an appropriate way, and also the basis upon which you were acquitted and other similar considerations. So, unfortunately, even in the Magistrates' Court, it's never easy to recover costs in the event of an acquittal. The bottom line is, unfortunately, for the most part, criminal charges are pretty much a financial tear-up from start to finish.